Welcome to our webinar. Please use the Slido QR code if you want to interact with us or ask questions in the course of the event. My name is Joe McNamee. I'm Senior Policy Expert at EU DisinfoLab. The tire maker Pirelli had a famous slogan, "Power is nothing without control." The associated TV advertisement showed Carl Lewis, the Olympic sprinter, getting ready to start a race while wearing high heels. If power is nothing without control, law is nothing without enforcement. Unsurprisingly, therefore, questions around enforcement were very contentious in the negotiations that led to the Digital Services Act. For the very large online platforms and search engines, the Commission was given overall control of the overall enforcement power. On a national level, a new role of Digital Services Coordinator was established. They are grouped together at an EU level in the European Board for Digital Services. So who are these Digital Services Coordinators? What do they do? What do they not do? And more importantly, are they going to be wearing Adidas running shoes or Christian Louboutin high heels? Well, to answer these questions, we're very lucky to have Dr. Julian Jaursch from Stiftung Neue Verantwortung, soon to be known as Interface, to answer all of these questions and more. Julian is project director in the field of strengthening the digital public sphere. He works on questions around tackling disinformation and regulating tech platforms. He analyzes approaches to platform regulation in the German, European, and transatlantic context, and develops policy recommendations that can be used by political and civil society decision makers. Personally, I know him as the guy who writes stuff that I wish I'd written. So over to Julian to get to the heart and soul of the matter.
Thank you so much. Much appreciated. I'm very happy to be here. Very much looking forward to your questions, Joe, and also from the audience, to hear your thoughts on the DSA. That's what I was going to talk about today, the DSA, and specifically the enforcement of it, the governance structure. This is loosely based on a paper I wrote, but there's so many open questions that really it's about a discussion, and hopefully we can get into that after this quick presentation. So my name is Julian. As mentioned, I work at SNP. We're a not-for-profit think tank working on a range of different tech policy issues. Some of my colleagues are working on cybersecurity stuff, AI, governmental surveillance, and as mentioned, I focused on platform regulations. A big part of this has been the DSA, which is also where I want to talk about it today. And as also has been mentioned, we will change our name soon to Interface, just to avoid any confusion if SNB disappears from your email inbox or feed in some time. It's not because we stopped working on these topics, it's just because we changed our name. Yeah, but let's get right into it. As I said, I want to focus on the DSA today, the Digital Services Act. My goal here is not to provide a very detailed or deep analysis and critique of the DSA. I will really focus on the enforcement side and some practical questions. But nonetheless, I think just very, very basically what the DSA is, just to recap. As I'm sure, though, many of you know, the DSA is a rulebook for online services, such as search engines, social media, online marketplaces, video apps. And the stated goal of the DSA is to create a transparent and safe online environment, or at least contribute to a transparent and safe online environment. And achieving this goal will be up to quite a lot of different organizations and actors that help enforce the DSA. A big role, as Joe mentioned, will fall to the European Commission, to national regulators, but also researchers, users themselves, civil society advocates, which is what I want to talk about today. When it comes to these national regulators, there's a bunch of different regulators and agencies that could play a role. Youth protection agencies, data protection, consumer protection. But per member state, there has to be one regulator that coordinates all these different other agencies. So each member state has to designate one particular agency to perform those coordination work tasks, and that's the so-called Digital Services Coordinator, or DSC. And the DSC, while coordinating is a key task, also has very many important other tasks, oversight tasks, networking tasks that particularly concern consumers and researchers. And I think this is also some of the vital things that I'm going to highlight. What you see on this figure that we created is the central role that I think DSCs can and do have under the DSA, because they're in touch with so many different actors. And you don't have to look at this in detail or understand it in detail, because I will go through these different actors now one by one and see how the DSA and the DSCs affect each of these groups. So to start with, let's have a look at the platform users, us as consumers, as citizens, as platform users. I think here it's important to reiterate the stated goal of the DSA just very broadly. It's meant to help users. Users and citizens and consumers are front and center in the DSA, and this should not get lost amid all the enforcement action. That's the standard that the DSA should be measured by, whether it helps platform users or not. But apart from this very general point, I want to raise one specific example where DSCs and platform users interact or work together, and that's the complaint mechanism. So users of online services can file complaints about potential DSA violations to the digital service coordinators. And this is in addition to the complaint mechanisms that are already in place at the platforms, for example, to report illegal content. So illegal content is still defined by national law. That's not defined in the DSA. And a platform usually has reporting channels that people can flag potential illegal content. So that's a national law platform thing. However, when a platform doesn't even have such a reporting channel, that's the DSA issue. And that's where users can complain to the DSC and say, hey, this platform is potentially violating the DSA because there's not enough reporting mechanisms, there's manipulative design practices, the transparency reports aren't good enough, questions like that. There are, however, also some open questions around this, whether this can work in practice. How user-friendly will these complaint mechanisms be? How easily accessible will they be? How can it be sure then that people can actually find them quickly and get a response quickly? So these very practical things, since we're at the very beginning of DSA enforcement at the national level, they will be crucial over time. It'll also be important that DSCs have a good coordination network within a member state, but also across member states, in case they need to forward complaints to a different country or to the commission, depending on the platform. Also, networks to consumer groups, to civil society, advocates, to individual users are important to understand how the complaint mechanism can be improved. And also explaining how platform users can benefit from the complaint mechanism, but also where its limitations are, will be very important in my view. And lastly, also for us as citizens, as consumers, as platform users, we do have a responsibility to get familiar with the DSA and with the rights that we have under the DSA and how we're supposed to use them. The good thing is that there are some of these networking efforts or awareness-raising efforts already underway. So just to highlight some very few of these examples, the Irish DSC has been was fairly early in updating their website and explaining what the complaint mechanism is and isn't, what it can and can't do. So they have a hotline to complain about DSA violations, for example, and here they explain it. A similar thing is happening in Germany for the German DSC, or soon to be DSC, even though Germany is not as far advanced as Ireland in the DSC designation. The Slovak DSC, they've actually started an awareness-raising campaign, not just about the complaint mechanism, but about the DSA in general, to educate people about the new law. And the Dutch NGO Bits of Freedom, they have also started a campaign about users' rights in the DSA, which is also available in English, in addition to Dutch. A second group I want to talk about are researchers and how they interact with the DSCs. Researchers have a fairly big role to play in the DSA, mainly with the goal of opening, or at least better understanding this black box of platforms and their content moderation and their algorithms and algorithmic recommending systems. And so one of the examples that I want to highlight here and how DSCs and researchers interact is the so-called vetting process for data access. So researchers can apply to receive data from very large online platforms. Very large online platforms are those platforms with over 45 million monthly users in the EU. And what this vetting means is that if I'm a researcher or research team, I can apply to the DSC, and the DSC will check whether I'm independent from industry, whether I have good data protection standards, data security standards, whether my research questions align with what's allowed in the DSA, and then hopefully, potentially, allow me to put in this request and receive data. This is potentially quite a big change to what we had before. Before, it was at times really hard for researchers to receive data from platforms. It was mostly based on voluntary commitments by the platforms. And now there's a legally guaranteed right for researchers to request platform data. Again, however, here there are some downsides, there are some open questions, because the system that I just outlined is there in theory, but in practice, not yet. And that's because there is an additional piece of legislation, a delegated act necessary to spell out some very important details about this vetting process and about the data access rules in general. And this delegated act is not expected until the end of the year. And so unless we know what's in this delegated act, how well it addresses some of the open questions, this system is in practice not helpful yet. And researchers have to show a little bit more patience and wait. And again, here, once the delegated act is there are some just very practical questions around the vetting process and how it will work. Will it be open enough for civil society organizations and not just university? How costly will it be? Ideally, it should be free. How burdensome is the vetting process, both for regulators and for researchers? So these are really some very, very crucial open questions that need to be addressed in the next couple months and maybe even years. What's also open is how well the outreach and the networking works. And this pertains both to regulators and researchers being in touch with each other, but also researchers amongst themselves, across disciplines, across countries, across research institutions. And again, here, if you want to take an optimistic view, there are already ongoing efforts to have these networking and collaboration efforts to get these going. For example, 2 German institutions launched a DSA data access tracker, where they try to figure out how successful people's data access requests are and will be in the future. Some of you might know the European Digital Media Observatory, EDMO. They have a dedicated working group very much focused on this vetting process and making sure that, or hopefully putting in improvements that this vetting process can work in practice. And lastly, this idea of an Institute for Research on the Information Environment. This is not specifically and directly related to the DSA, but it is meant to foster international collaboration and provide an infrastructure for data-driven research. So I do think there's a strong connection to the DSA, and it's another good example of these types of researcher networks and collaboration already happening. The third group I want to highlight is civil society. And before I get into a specific example of civil society, I do think it's helpful to remind ourselves of the very many tasks that civil society is explicitly given in the DSA. Don't want to go through all of these. What I just want to show with this, there's a lot of articles in the DSA that specifically mention involvement of civil society. And this is fairly promising and helpful because civil society researchers and advocates have worked on platform issues and have tried to help understand platform issues long before the DSA was in place, right? On gender-based violence, on disinformation, on algorithmic transparent recommended systems. I picked one example to highlight the role between the interaction between DSCs and civil society here, which are trusted flaggers. And here again, DSCs have a very important role. They are the ones running the accreditation process for trusted flaggers. Trusted flaggers are organizations whose flags for potentially illegal content are dealt with in an expedited way by platforms. And some platforms already had that before the DSA on a voluntary basis. Now they are mandated to have such a system in place, or at least to allow for such a system to be in place. Nevertheless, the company's own trusted partner or trusted flagger systems can still be in place in parallel to the DSA system. The benefit of the DSA system could be that a trusted flagger organization has direct access to the DSC and they're not dependent on corporate rules around trusted flagger organizations. Once again, though, there are some downsides, some open questions, because the DSA trusted flagger system does come with a lot of transparency obligations. In my view, that's a good thing. I think that it is necessary to have some transparency around who's doing the trusted flagging and how. Nonetheless, it is an administrative burden that civil society organizations, trusted flaggers, will have to deal with. The DSA also does not foresee a permanent or structured advisory mechanism between DSCs and civil society, or between the Commission and civil society. So all these tasks and roles that I showed on the previous slide, they are interspersed in different articles, but there's no permanent structured advisory mechanism. In my opinion, that could be useful to have such a thing. I think it could help regulators get outside expertise, and it would help civil society have a more permanent and structured avenue of exchange with regulators. I personally think the European Board for Digital Services could be a good place to establish such a mechanism. The Board for Digital Services is a new DSA advisory body. It consists of the Commission and of all the DSCs, and it is explicitly allowed to invite external experts. And I think this would be a good opportunity for regulators to be in touch with civil society in a structured way. Going back to trusted flaggers for just a second, there are supposed to be some guidelines around trusted flaggers and how the accreditation process works. The Commission can put these in place, but so far that hasn't happened. So the Commission has not yet published these. However, the DSCs themselves have started on a framework on trusted flaggers to get a kind of minimum standard across the EU. And some member states have already started putting these into their individual national legal systems or DSC setups. So the examples that I've provided here from Austria and from Ireland, which have published documents or guidelines, instructions for the trusted flagger system in their respective countries. And now returning briefly to this idea of an advisory body, as I said, it's not foreseen in the DSA at the EU level. It is, however, discussed at the moment in Germany. So the German DSC will likely have an advisory body. There's supposed to be 16 people, 8 from civil society organizations, 4 from academia, and 4 from business associations, with the task of consulting with the DSC, making recommendations. And I'm not trying to say that this is the only way to go, to have an advisory body, or even the ideal way to go. In fact, I actually think there might still be some weak spots in the German system when it comes to the specific task, or also the way that the membership is set up. If you're interested in this type of DSA advisory council work, there's a whole different paper on this. But nonetheless, it is one way to ensure or to allow for exchanges between civil society and regulators. Other ways could be conferences, consultations, workshops, roundtables, stuff like that. And lastly, one group I want to highlight is platforms. The DSCs will be in charge of overseeing platforms, meaning they will check whether companies comply with the DSA or not. And this will mostly concern not very large online platforms. So those that fall below the threshold, that don't have 45 million monthly users in the EU. And it's somewhat harder to determine these smaller platforms than the bigger platforms. So for the very large online platforms, it's very clear. The Commission designates them. We know there's 22 of them right now, and there could be more or less in the future, depending on the Commission's designation. For smaller platforms, there don't seem to be EU-wide statistics. So I asked around in some of the member states, and the DSCs got back with some rough estimates. And this is really important for me. These are estimates. The member states have very different ways of calculating this, also of a different time frame. So this has to be taken with a grain of salt. Nonetheless, I think it's fair to say there's got to be thousands, if not tens of thousands, of platforms and intermediary services that don't meet the VLAB threshold in the various member states. And this leads over to one of the key things that I think are important for the interaction between DSCs and platforms, which is understanding the multitude of platforms. There's different sizes, there's different business models, there's different age groups that use the platforms, there's different purposes for these platforms. And understanding, appreciating these differences and what the corresponding risks are, that will be an important task for DSCs, also in collaboration or in exchange with the platforms. Here, I think one of the important things to remember on the plus side, so to speak, is the division of labor between the Commission and the member states. As I mentioned, the Commission for the bigger platforms, the member states for the smaller platforms. For the potentially weak or negative things, open questions, as this very rough estimate overview that I presented shows, it's not that easy to monitor the type and the number of platforms, also emerging platforms in the member states. And just getting that under control will already be an important task in the future. And I think going back to my earlier point about this advisory body and the Board of Digital Services, here I think will be a key thing where different DSCs from different member states can collaborate to share experiences on DSA enforcement and kind of figure out good and bad practices. And whether that works is one of the big open questions at the EU level. All of these things that I mentioned are quite costly. So finding the right people, hiring them, training them, retaining them, building expertise, building networks, having the infrastructure to deal with data access, all this costs a lot of money. So without resources, without budget, without staff, none of the things that I mentioned will work out well in the future. And so it will be very important to watch whether the Commission and the member states over the next months and years will equip the Commission and the DSCs with the adequate budget and resources to actually enforce the DSA. And the same actually applies to civil society organizations, to universities and other research institutions. They all need money to enforce the DSA. And one idea that could be discussed, I think, is pooling different types of funds. So for example, the fees that some platforms have to pay for DSA enforcement, combining that with governmental money, with money from foundations or other philanthropic efforts. If you pool all of that, if you throw all of that into one pot, it might make it easier for some organizations, not all organizations, but some organizations to take and use that money without appearing compromised and without relying on one source, either political or corporate. I want to close by highlighting 4 potential areas of tension when it comes to the DSA and specifically the role of the DSCs. One area is this idea of the DSCs becoming a key node for DSA enforcement. As I try to explain, the DSCs are in touch with a lot of different actors at a lot of different levels, political levels, and this could be really beneficial to create a dynamic and innovative structure of enforcement, of collaborative enforcement, if resources and motivation is there. If that's not the case, I think there's a risk of a rather weak and static DSA enforcement. The second potential tension is between public interest and corporate and political interest. Sometimes these align, sometimes they don't. And here it will be important for the DSCs to make sure that there are guardrails in place to safeguard their independence, both from corporate and from political influence. This could be done, for example, by being open about outreach and lobbying efforts with a transparency registry, for example. But it could also just be explaining the role of the DSCs and acknowledging the limitations of the DSCs, because they're not in charge of everything when it comes to the DSA. A third area is the idea to create avenues or create opportunities to compromise. And this example I want to bring here is the board. The board at the European level will bring together DSCs from all member states that have very different histories and focus areas. And it's been very promising that even before the DSA was fully in effect, these DSCs and soon to be DSCs have already been collaborating on an informal level. But what happens if there's conflict between DSCs or between DSCs and the Commission? That's why this type of trust building and network building needs to happen right now, so that there can be compromises found in the future. And lastly, very similar to this idea at the board that I was just talking about, just with external experts, this idea of having an open door policy at the DSC, openness to talk to civil society, to talk to academic researchers, journalists, get their expertise, get their analyses, recommendations. That type of openness and structured outreach is important if DSCs want to become this hub for DSA enforcement. All of these experiences that I highlighted in the past couple of slides, they can be really helpful in the upcoming evaluation of the DSA. It might seem a bit early to talk about the evaluation since the national level enforcement isn't even in place, but it is one of the next big things that the DSA will face. In a couple of years' time, there will be an evaluation, and DSCs will be in a very good position, hopefully, to contribute to these evaluations, because they are charged with enforcement and they are in touch with so many people. And then the next step from that will be to actually change the DSA if the evaluation shows that that's necessary, to be open on the part of regulators and lawmakers to actually improve the DSA. Now, I think we have to be very aware that opening up the DSA, that we'll have to brace for more corporate lobbying to water down the DSA again at that point. But that just goes to show how important a strong public interest collaborative effort is to be that counterweight to any corporate interest. And with that, I want to close with this call, for collaboration. I'm very much looking forward to your questions, and feel free to reach out. And thanks so much for having me and for listening.
Thank you, Julian. That was really an extraordinary amount of clear information in the time that you were given. There are some questions on Slido. So I'll start with, I think, a fairly straightforward one from a researcher who is from an EFTA country and therefore doesn't have a DSC. Which DSC did they ask to be vetted for data access requests?
Yeah, thanks for that question. So in general, it should be the case that researchers outside of the EU can also apply for data access to receive data. A couple of things here, though, that are maybe a bit of a caveat. So first of all, just the reminder again that the Delegated Act is not in place yet, and the Delegated Act will hopefully clear up some of the questions of how exactly this will work in practice. So once we have that, I think there will be hopefully more clarity around that. But for now, what I can say is that you can apply to the DSC in the country where the platform is headquartered. In a lot of cases, that will be Ireland, because a lot of the very large online platforms have their European headquarters in Ireland. The Irish DSC is well aware of that. They have stated that publicly, that data access is one of their priorities, or will be when the Delegated Act is in place. So Ireland would be one option, but there are other very large online platforms in other countries, in the Netherlands, in Luxembourg, Cyprus, Czechia. So these would be the DSCs that you can go to. I would imagine that you can reach out to them. Another caveat that I want to highlight here is, while the data access regime should be open to non-EU researchers, it is important to note that the research that's actually being conducted has to relate to so-called systemic risks in the European Union. So it will likely be the case that you can't request data to study something that's outside of the EU. The systemic risks mentioned in the DSA are relatively broad. It's the distribution of illegal content, its negative effects for minors, for civic discourse, for example. So these are rather broad topics, but again, they have to relate to the EU. So that's another important thing to remember.
Thank you, Julian. A very neat question that summarizes a lot of what the DSCs are supposed to be achieving for people in Europe next. If a French person wants to complain about an intermediary in German, to whom do they complain, and can they complain in their native language?
Yes, they can complain in their native language. They can also complain to the DSC in their home country, for example. But what will happen, or what should happen according to the DSA, is that the complaint is being forwarded to the responsible agency. So to stick with that example, if somebody complains from France about a German intermediary, you can go to the French DSC, but the French DSC will very likely, no, not very likely, they will have to forward it to Germany, because the platform, the intermediary, is based in Germany. A similar system is in place for very large online platforms. So if someone complains about a very large online platforms, the complaint will go to the European Commission, because the Commission is largely responsible for the very large online platforms.
And implicitly, the questioner also asked who's in charge. So for a non-FILOP, it would be the country of establishment.
Yes, that's right. You perfectly summed it up. Yeah.
And another interesting question on a number of levels on trusted flaggers, because the Irish DSC's application document quotes foreign interference in election disinfo as potentially illegal, but the DSC talks, Article 22 talks about illegal content. So the question is this are trusted flaggers supposed to deal exclusively with illegal content or gray areas like?
I don't know. This is a question that I can't answer, and I would hope that the application documents provide some clarity on that, which I guess is not the case, or at least not immediately. It does speak to one of the challenges that I see in general with the DSA, or at least with the communication about the DSA, public communication, is that disinformation and illegal content are thrown in the same pot, when I don't think I need to tell this audience that that's not always the case, right? Some disinformation is illegal, but a lot of disinformation is not, and getting clarity on that distinction would be important. But I'm afraid I can't answer that specific question. I would imagine that the trusted flaggers would have to have very clear statements of what their expertise is on what content they can flag. But if there's a lack of clarity in that case, I think that speaks even more to the necessity of EU-wide guidelines and clear legal language on what that means.
Thank you. I want to skip to, I think it's from the same person as the previous question, from Sophie on, I think it refers to Article 40 access. The basic issue that's being raised is Article 40 is for entities that are independent from commercial entities, but there are not counter-disinformation actors who are commercial entities. Do they have any grounds for gaining access to data under the DSA or under Article 40 in particular?
I'm also unsure about this one. Maybe there are people working more closely on the data access that already have an answer. I personally would have to wait for the delegated act for some clarity on that. What I can say is the Article 40 that you alluded to, that's the article that explains the data access rules in the DSA. And it does say that you have to be independent of commercial interests. Now, if you can still be a commercial for-profit research organization, maybe that's the case, and maybe we just need to wait for the detailed explanations in the delegated act to explain that. What my understanding was that the key here regarding the financial independence is that the actors who request data from platforms are independent of those platforms. I think that would be an important thing, but it's also very logical, right? Because the platforms have the data. So just to avoid conflicts of interest, I think this language is in there and needs some detailed spelling out in the delegated act. So this is again a thing where I have to apologize for not knowing the answer as of now.
We can, however, promise some more clarity on that, because the draft delegated act, it will be open for consultation at the end of next month, and in the first half of next month we have a webinar with the desk officer from the Commission responsible for that. So you can
perfect. Look at that plug for the next webinar. Yeah, that would be very interesting to me as well, and to read the draft delegated act, and hopefully a lot of people from this community, but from other researcher communities, actually have the opportunity to comment on it and to provide some more improvements.
And a question that I have no insights on at all. Has any DSC made progress on Article 21 implementation?
Not as far as I know, but here I also have to say that I haven't followed the developments in all member states. So I'm sorry that I don't have a good overview here. I can say for the German case that there is not any out-of-court dispute settlement body officially accredited or designated as of now, which is partly the case because we officially don't have the law yet, but also because the system before had not been in place. So I'm afraid that apart from the German situation, I can't provide any details.
The next question is on VLOPs, on the non-VLOP Telegram, which, funny enough, I was working on yesterday with dealing with these questions. Who is their DSC? Does any DSC already have a signaled interest in looking into Telegram's activities?
Not that I know of. Again, my relatively narrow view from Germany is that I know that regulator that was in charge of the German law that is now being replaced by the DSA. They tried to reach out to Telegram. I don't know the exact year anymore, but years ago, and it was quite difficult to reach them. And so, that would be a natural starting point for me to think about what we can learn from that experience. And maybe that means that some of the German folks will look into that, but I don't know. And I don't think that Ireland is the European establishment for Telegram, is it? I don't know, Joe, if you know, but I mean, the Irish DSC would be in charge if Telegram was headquartered there, but I'm not sure that it is.
To be honest, I had a very quick look yesterday, and I couldn't immediately identify what had been.
Exactly. That was the whole problem that was a whole challenge in Germany too, where it was very difficult to find the actual headquarters. I think in the end, the letter was delivered to a post box in Dubai, if I'm not mistaken. So it is not that easy if you don't have that headquarter in the EU or even outside of the EU, and you kind of run around without a DSC, so to speak.
So next question is on access that's already available to repositories of large platforms. Is there any research that you're aware of or results that have come out?
No. Well, let me differentiate between two things. No, for the data access rules that are described in my presentation, like these data access rules where you have to become a vetted researcher. So because that system is not working in practice, obviously there's also no data access yet and no results. However, there have been first data access requests put in. One that I know of is an NGO called Algorithm Watch, headquartered in Germany. They have put in a data access request to Microsoft, to the German DSC. The German DSC forwarded to Ireland, and Ireland said, "Sorry, we have to wait for the delegated act." So this is happening, but the results aren't there yet. I'm sure that Algorithm Watch and other organizations and universities will publish this because they have to. That's one of the rules in the DSA. If you request and receive data under the Article 40 rules, your study results have to be public. So that's the one thing. The other thing is that there are already rules in place that very large online platforms have to share publicly available data, such as public posts on Instagram or Twitter or public videos. But here too, there are some obstacles that researchers face because this data is not easily accessible, and the compliance with this particular rule in the DSA is actually not that great at the very large online platforms. And the Commission has requested more information on how platforms intend to comply with this rule in the future. So this is another big open question, obstacle that researchers face at the moment of even this publicly available data not being easily accessible.
And so my backstory is that I was, in my previous job, I was in the negotiations and for the DSA, and this question was discussed a lot. What have we learned from the GDPR enforcement flaws, and how will the DSA enforcement be different?
Well, maybe you can chime in here too with your experience. I would just be quick and say I do think they have been learning. The structure is different. A key difference is that in GDPR enforcement, data protection rules, the European Commission doesn't have a big role. That was, I think, and Joe, you will know this better than I do, it was discussed at some point. It was in some of the earlier drafts, but it didn't make it to the final draft. That's very different from the DSA. The Commission had a big role in enforcement from the very beginning, but the member states actually increased the Commission's role over enforcement regarding the very large online platforms. I think that's a very big difference, that you acknowledge that for these cross-border, very large platforms that don't just work in one EU member states, you have the enforcement powers largely with the Commission. Not only, there's still ways that member states can have a say, but largely with the European Commission. I think that's a key difference. Whether that works better is still remains to be seen, right? Like we're still at the early stages, but it is a big difference. But yeah, Joe, I mean, like, do you have are there any experiences that you can share on this?
Well, I can, without divulging any great secrets from inside the EU decision-making process, the question of how do we learn from GDPR enforcement flaws was repeatedly discussed in the Parliament in the interinstitutional negotiations. And one key thing was, for the big platforms, we have to find a way of them not going, of them not forum shopping within the EU. And therefore, we have to find something else. And the something else was initially an agency set up for that purpose. And there is an ideological objection among certain political groups in the EU to any new agency being set up for any purpose, and therefore that option was off the table. So the only middle ground between the agency that wasn't going to get support and member state-led enforcement, which nobody wanted either, was a middle ground, which was the European Commission. So it wasn't an option that anyone designed. It was the option that was left after everything else fell off the table.
Interesting. Yeah. Thanks. But I mean, I've also read critical things about GDPR enforcement and also somewhat critical, but it is also important to note that it's not all bad with GDPR enforcement too, right? It took a lot of time to get to the point we're at now, and there's certainly like big gaps. But maybe there were also some things that work well in GDPR enforcement that they took over, or do you think it was mainly bad practices that they tried to avoid?
The latter, unquestionably. I can safely say in all of the discussions I heard, nobody said this worked well in GDPR, let's carry it across.
Interesting.
That's not to say that there aren't good things. But
that's what I was trying to say. Yeah. Okay.
Moving on to the next question. How do we define systemic risk?
I can't.
Looking at X and the disinformation there as an example, how do we move forward on that concept?
Yeah, also thanks for that question. And another extremely pertinent and important one. I don't know. I don't know how to define it. There is certainly the broad definition in the DSA, but spelling that out for each individual data access request, I don't know how you can find a definition that applies to so many different things and covers so many different research disciplines and research questions. So I think this will be something that, again, sorry to repeat myself, but hopefully the delegated act will specify a bit more what researchers need to expect when they define systemic risk. And I think it will really depend on this type of collaboration, experience sharing, networking that I mentioned earlier between researchers and learning what worked and what didn't work. So without knowing this specific case, this information, like my immediate thought would be that there would have to be concern with systemic risk for civic discourse in the EU, maybe particularly around election. But you probably did that with your request and might not have heard back. So also ensuring that researchers know what happens if a research request gets rejected is just as important as knowing what happens when it gets accepted. But yeah, unfortunately, another question where the delegated act will be an important thing, and looking at the systemic risks.
And showing the speed and efficiency of the DSCs, we have an answer to one of the questions from the Belgian DSC.
Perfect. There we go.
Which explains that that they are the DSC because the digital service representative.
There you go.
Based in Brussels.
Thanks for that update. That's good to know. Okay, there we go.
And if that's an indication of the DSC's speed and efficiency, we've got nothing to worry about.
See, there we go. That's a promising informal and outreach efforts that I was talking about. Thank you very much for the update.
difficult question. Can the appointments of trusted flaggers by the DSC be challenged or appealed?
I'm not sure if they can be challenged. I know that the accreditation of trusted flaggers can be repealed by the DSCs. So if the trusted flaggers don't meet the requirements, you can argue whether these requirements are strict and detailed enough. But if they don't meet the requirements laid out in the DSA, they can get their accredited status revoked by the DSC. I hope that at least partly answers that question.
I see numbers on the Q&A in Zoom. If anybody has questions, that they need to be posted via Slido, just for clarification. Next question, what is the responsibility of the DSC under the Article 53 right of complaint?
The right of complaint in Article 53, that's the first type of complaint mechanism that I mentioned in the talk. That's the idea that users can complain about potential DSA violations. And to me, what was important for me to understand when I read the DSA is the differentiation between complaints about individual pieces of content and complaints about larger structural violations of the DSA. And the latter, these structural violations, that's what Article 53 right of complaint is about in most cases, or it will be in most member states. So some examples. First of all, the example that I gave earlier, this reporting mechanism for illegal content. Most platforms already have that before the DSA. Now it's mandatory. They have to have it. If they don't have it, that would be something that you can complain about to the DSC under Article 53. But basically, any other DSA violation, you can also go to the DSC. So, for example, the DSA says that platforms can't be designed in a manipulative way, or something that misleads consumers. If that's not the case, you can complain to the DSC. The DSA says that platforms need to provide transparency around online advertising, like label online advertising. If they don't do that, people can complain to the DSC. So these are some of the things that I think will be helpful for users to tell digital service coordinators about. And digital service coordinators, in turn, can also use this as a kind of data gathering, intelligence gathering mechanism. So if they receive a lot of complaints about missing reporting mechanisms, for example, or bad transparency reports at a certain platform or in a certain member state, then this will allow them to potentially take action, or at least have a closer look at potential violations.
Excellent. We're at the end of the questions from Slido so far. I had a question with your broader look at different DSCs. Do you see any particular differences in the nature and approaches of the DSCs that you've looked at so far, or are they developing in a generic, coherent way?
I don't know yet, I have to say. The development, whether that will be coherent, I think that will be interesting to watch over the next couple months when this board that I mentioned that brings together all the DSCs, when that springs into action, when that actually is established. As far as I know, they've only had 2 meetings so far, so this is at the very beginning, and we'll have to see whether that becomes a strong, coherent mechanism. Looking back, though, I think what is promising is that even before the DSA was in place, there had already been exchanges between regulators, and they have been eager to form working groups on different topics, such as data access, trusted flaggers. And I think that's somewhat promising that this type of informal collaboration was there even before they were officially, the DSA was in full effect. And what's also interesting to mention, I think you alluded to that with your question, is that these regulators come from very different fields. And some of them are media regulators, some of them are telecommunications regulators. There's a small number, the definite minority, like consumer protection or competition agencies, but very different historical backgrounds, very different historical focus areas. nonetheless, now they have that joint task of overseeing compliance with the DSA, being in touch with all these different organizations and people that I mentioned. And hopefully that can kind of bring them together and form this type of coherent body that you were talking about. But it is maybe a little bit too early to finally say whether that's happening or not. It would certainly be useful, I think, for consumers if that happened.
Okay, just one final question. Are you hopeful that the Commission's push to have civil society more involved in the board's deliberations will be successful or not?
Yes, I do want to be optimistic, because otherwise working in this space would be a lot harder. I think the commissioners and the DSCs, for that matter, at least the ones that I've been in touch with, they have been very good about being open to civil society inputs. For example, hosting events, hosting webinars. That being said, there's still a lot of room for improvements. Sometimes these meetings are very ad hoc. Sometimes civil society doesn't have a good way to set the agenda, and very limited amount of time to speak about fairly complex topics. So I think over time, hopefully there can be improvements on the side of civil society, on the side of commission, the board, the DSCs, to get to a mechanism, a way, some sort of structured exchange where people can talk at eye level, and the deliberations and the discussions actually are in somewhat of a meaningful structure that can actually affect change. It's not just an exercise where you can say, oh, look, we included civil society, but nothing ever comes of it. So yeah, to summarize, I think very good steps already taken, and a lot of steps for improvement still there. And at this point in time, I think that's a decent place to be with the outlook for improvement.
Okay, I think we can wrap up there. That was really fantastic, Julian. You provided so much information so clearly. So thank you on behalf of...
Thank you for all the questions and for hosting and moderating.
And brilliant questions from the audience. So thank you to them for ensuring the success of the event. For people who are logging off now, they will be taken to a feedback option. So feel free to give your views, good, bad, or brilliant. And we look forward to seeing you shortly for our next webinar. Thank you again, Julian. Thank you for the audience. Thanks for the questions, and see you soon. Bye-bye.
Thank you very much. Bye.